Can you all hear me? I don't know what's going on. I may have to start over. You're reporting this channel, Chris. Help. Oh, what's the problem? Report this channel. Shut it down. No, no, someone's not happy. Can you all hear me now? Okay. What is the deal with Chris? Chris, help. What are you upset about? What's the matter? Ugh. Is he trolling? Chris help is trolling. I mean, he does realize he tried to do that. I'm just gonna get it back up. Oh Lord. All right. For the third time. I'm wondering if he was joking. Y'all know the trolls, they're like target practice for me. It's like target practice. You're gonna shut someone down for reading a lawsuit. It's weird. Oh, Chris, you got muted, bro. Hey, you know. I didn't even take that as a threat. I was like, oh, that's laughable. Okay. Let's go. Oh God. All right, we're gonna try this again. I did not even know it skipped out or anything. So please let me know if you can hear. Can you all see? One in the chat if you can hear and see. Are y'all good? Yeah, you get used to it after a while. I mean, I've been on YouTube for almost 4 years. You know. Yeah, I've heard worse, be honest with you. Yeah, I've been cussed out in other languages. I already told you all once before. You have not been cussed out until you've been cussed out in Hindu. It is what it is. Y'all good? We all good? Okay. All right. We're gonna do this again for the third time. This time I'm not gonna expand the full screen because what's happening is I start reading and um I don't see the comments. And I don't see what's on StreamYard. Later, like if you ever wanna, oh, that's nice. If you ever want to do a legal collab, reach out to Miss Mandy and we will work something out. I would love to have you on sometime. That'll work. I gave my email, but y'all feel free to send me an email. Did you get the email I sent you today? I have not been able to check my emails since this morning. I apologize. I will be going through my emails because I see you guys emailing me saying we can't hear. All right. Oh no, we don't. Yeah, no, we don't call nobody monkeys now. We don't do that. I think you know it's unnecessary. And why come over here and do that? Don't come over here and do that. That this isn't Jedidiah's channel. It's mine. Why come over here and do that? The hell is that? All right, whatever. If that person want to be mad at him, be mad at him. Direct that energy to him. But don't come here with that nonsense. Don't call nobody a monkey. We ain't doing that now. Good grief. Okay, let's get to it. All right. Case number 25-CV-11225. Jedidiah Brown versus Ladell Lewis, Candace Mushad, Joanne Gurley, Terrence Green, Vincent Villarreal, and Officer Guy in their official and individual capacities, which is a good thing, just in case something happened and they're no longer in their official capacity. Uh, they can still proceed and issue a judgment against these individuals, the defendants. So I just said their names so I don't have to keep saying it over again throughout the complaint. It's 31 pages, so I'm not gonna read it all. I'm just gonna touch on certain parts of it, okay? Okay, cool. This action alleges inter alia violations of the First Amendment. And you see the statute codes there. I'm just zoom in a little bit better. All right. And you guys can see the statute codes listed here: 42 USC 1983 and 1985, as well as violation of the Michigan Open Meetings Act, MCLS statute 15.261, etc. Um, by members of the City Council of the City of Flint, infringing upon the rights of plaintiff as arising under those aforesaid bodies of law. So the plaintiff, Jedidiah Brown, by and through his attorney, Lento Law Group, um, brings this action for damages and other equitable relief against the defendants named and listed in the intro. This is the City Council of the City of Flint, Michigan, that's gained nationwide recognition, not in a positive way. They have a wealth of video segments from various council meetings that have gone viral on social media. So that's plenty of video evidence that he could use in court. And I'm gonna have this live stream up to the public until Saturday, and then after Saturday, it's gonna go strictly to members only. Reason being is because I expect this to be amended. Considering the arrest, I'm sure they're going to want to amend this lawsuit to include that incident so that they can kind of handle, you know, both of the incidents at once, if that makes sense, instead of filing two separate lawsuits. So they're speaking on the Flint City Council being unequal in an application of council rules, personality conflicts, which impede city business, and the sheer frequency with which council meetings descend into a circus-like spectacle. Many of you have seen many of their council meetings. I think I've seen one, maybe two, and one of them was on No Apologies live stream. And I don't even know if they had a meeting. I don't think they had a quorum. So if they're not having a meeting, they're having chaotic meetings. They're citing a specific meeting that occurred on April 28th, 25 as the example of the dysfunction on April 28th meeting, rather than it being a particular councilman or councilwoman facing the despotic and dictatorial caprices of council leadership. Rather, it was a private citizen and member of the public in attendance at this particular meeting who found both his constitutional rights and his rights as arising under Michigan law under attack from various members of Flint City Council and the police force. The same police force we witnessed arrest him and tow his car for disturbing the peace. God, that arrest was so stupid. Y'all let me know if you can still hear and see so far. Jurisdiction and venue. This is an action for damages against the defendants who at all times were acting under the color of state law and in vindication of plaintiff civil rights secured by the statutes listed here and the First Amendment of the U.S. Constitution. This court, and this is court being, as you all can see, the District Court for Eastern District of Michigan, being the proper venue pursuant to 28 USC, which is federal law here, 1391 sub B1 and sub B2. As upon info and belief, all defendants reside in the district. So the court is proper over regarding this case. At all times, relevant here to the plaintiff, Jedidiah Brown, is upon info and belief an adult resident citizen of the county of Toronto, state of Texas. And I'm not going to read his address. And then they give a background on each of the defendants. So I'm just going to kind of go over and summarize. Liddell Lewis is the city council president, resides in the county of Genesee. Am I saying that right? Let's see. In the state of Michigan. The next defendant is Candice Mushat, the city council vice president, who also resides in the county of Genesee, state of Michigan. The next defendant being Terrence Green, the Flint, Michigan chief of police, who resides in the county of Genesee. Um, and the service process they served the lawsuit is what's listed here. Not sure. And I'm not gonna, like I said, I'm not gonna say it out loud, but it says here his employment address for service of process, and they put down what they believe to be accurate. Nowadays you have these, the courts use some sort of e-file system. So depending on what it is, you can actually opt to have, the other party e-served. Um, and then just kind of make sure you file your certificate of service to go along with your complaint or your filing. The next defendant is Joanne Gurley, the city attorney for Flint, Michigan, residing in the county of Genesee. The defendant, Vincent Villarreal, a detective with the Flint City Police Department. What was the detective doing? Well, why would a specific detective be involved in anything with infringing upon some rights? I expect that from the police, but not a detective. He also listed the employment address that you all see here. I'm assuming that's the police station because you're talking about the police and the detectives under the police department. So let's just assume this address is the police station. And then you have defendant Officer Guy, a police officer with the Flint City Police Department. He also listed the employment address. So yeah, 210 East 5th Street, I would assume is the police station address. All right. Let's see. The true names and capacities of persons or entities, whether individual, corporate, associate, or otherwise, who may be responsible for some of the claims alleged herein are currently unknown to plaintiff. Plaintiff will seek leave from the court to amend this complaint to reflect the true names. Okay, there you go. It's going to get amended either way. There it is. So when they amend it, more than likely his attorney is going to add in the actual arrest and how all of that was handled, because that was the dumbest arrest ever. It was just absolutely ridiculous. They towed his car for disturbing the peace. My God. Factual background. So plaintiff hereby repeats all of the allegations contained above, which is, and I want to reiterate, these numberings you see here, they are referred to as paragraphs throughout, any complaint. So what they will say is, as you see each charge or count of the allegations, it'll say realleges, and it'll have the paragraphs and then the numbers listed for each paragraph. So paragraphs 1 through 17 is being repeated in paragraph 18. Next point, April 28, 25, Jedidiah Brown was present at the Flint City Council meeting. And the factual background should strictly be facts. Okay. Just things that are indisputable, not a matter of someone's opinion or anything or some sort of conspiracy theory. It should be factual information, which is why I love reading court documents. Being a political advocate on behalf of the citizens of Flint, Michigan, apart from having an interest himself in the goings on of the city, plaintiff intended to speak at the meeting and was also recording the meeting, as this is right in the interest of transparency. On the same date, at the commencement of the meeting, defendant Mushat read aloud the established rules for decorum to all in attendance. In doing so, she recited the pertinent sections of the Flint City Code addressing assault, battery, and disorderly conduct. Furthermore, defendant Lewis explicitly cautioned the assembly that any individual preventing the peaceful and orderly conduct of the meeting would receive a single warning, and if the disruptive behavior persisted, that individual will be subject to arrest. The problem is you have police officers doing stuff like this, and because they don't really know the law. Hey, how you doing? Seeing some comments here. Let me just put these up right quick. Yeah, I agree, Saint. Totally ridiculous. Who wrote this? His attorney. His attorney drafted this pleading. Hey, Agnes, how you doing? So his attorney filed this to the court. But it's the thing is it's going to be amended because they want to list the actual names of the individuals and hopefully add on the actual arrest and all of um the problems that persisted from that one incident because disturbing the peace. I mean, they treat that like it's a murder charge. It's ridiculous. No one was murked. And no one was murked in that meeting. No one. It's crazy. It is a fundamental principle that a quorum defined as a majority of all elected or appointed and sworn members of the council is required for the valid transaction of business at any council meeting. In the absence of a quorum, the remaining members may only adjourn the meeting to a later time or date, provided that the proper public notice is given. That's kind of a standard across the board. I mean, we've seen that same, sort of principle regarding, Robert's Rules of Conduct, Open Meetings Act, any specific local ordinances in place. It's typically the same across the board regarding a quorum. Recently, Flint City Council has experienced significant difficulties in assembling I'm sorry, a sufficient number of elected or appointed and sworn members to meet the quorum requirement necessary for the conduct of official city business. This ongoing issue has contributed to procedural irregularities and underscores the potential for arbitrary decision making during council meetings. So, no quorum, you can't get anything done. On the April 28th, 25 meeting, despite Flint City Council meeting lacking a quorum and not being in an active legal session for the transaction of official business, defendant Lewis, acting in her capacity as council president, proceeded to call for public speakers. So they had not established a quorum, but they still conducted this as if a quorum had been, you know, uh, voted and agreed upon. Usually that's something that's motioned to, start to initiate the meeting. And then they'll say at the end, okay, we have a quorum. So if that didn't happen, you're allowing people to come up and speak. You're not really interrupting a meeting. Is that, I mean, am I understanding this wrong? Is it just me? It was during this meeting that the events giving rise to this civil rights complaint occurred. It is also important to note that city council meetings are commonly recorded by members of the public in attendance, as many other meetings are, who record with all manner of electronic videotaping equipment, camcorders, camera phones, etc. That is to say, also, um, the couple meetings I have seen, they had a section reserved for the media, and it's roped off. That way, all the media is in this little boxed area that's roped off, especially if you're using like a tripod or if you have equipment that could block the view of the regular members, you know, in attendance for the meeting. So they have a designated area for, you know, the media, any member of the press to record the meeting. So, I haven't read this in its entirety, but I really hope they didn't make that an issue when they have a designated area for people to record a meeting. That is to say, there was nothing unique about the fact that plaintiff chose to record the meeting, nor was there anything unique or unusual about plaintiff's camera specifically as compared to other cameras that have been used to record these meetings in the past prior to the subject incident, which will be complained about herein at all times leading up to thereto. From nearly the very beginning of the evening's council meeting, defendant Lewis adopted a needlessly aggressive tone towards the public because you're corrupt and the flunkies and goons you keep around you are just as dumb and have the worst attitude ever. I guess the defendant Lewis decided to be sassy that day. Mighty funny how defendant Lewis in Flint is seeming to act and behave the same way as Lewis Lacey, the potato head. Mighty funny. Good grief. Speakers were required to complete an information card with their identifying details and place it in a designated box. However, upon info and belief, defendant Mushat retrieved the box prior to the formal start of the meeting and proceeded to read the opening rules. This action effectively prevented others speakers from submitting their information, despite the fact that the meeting had not officially commenced and the council had not met the quorum requirement. Oh, they can't. Flint City Council can't be this dumb, and if they are, they should definitely lose this lawsuit. Are you serious? Oh God. Okay, let me know in the comments who is worse right now, Flint City Council meetings or the buffoonery that Super Stupid kept up in the village of Dalton and Thornton Township. Because I'm seeing a theme here, a pattern. Good Lord. Despite the this is unbelievable. Despite Flint City Council meeting lacking a quorum, plaintiff was designated as the first of only a few speakers. Plaintiff approached the podium to address the members present and to raise concerns about several irregularities in the actions of the city council under the established rules. Plaintiff was allotted 3 minutes to speak, during which he detailed issues including the alleged reallocation of $75,000 in funds. Good Lord. The failure of council members to disclose personal financial interests tied to city contracts. So, yeah, okay. Sounds like no RFPs and no contracts with vendors here. And accusations that police were being weaponized against constituents because, uh, corrupt officials have to weaponize police departments just because reasons. Intimidation, threatening. Good Lord. You would think if they're stealing money, they would want to keep a low profile and not weaponize a bunch of guys and women with guns and weapons and arrest powers. You would think they would not want to do that and bring more attention to themselves. But oh man. After plaintiff made his comments at the podium, he vacated the podium and returned to his seat. Subsequently, defendant Lewis instructed the clerk to call the next speaker. Importantly, no member of the city council issued any warning for misconduct during or immediately after plaintiff's public comments. As background, which is pertinent to the matter, plaintiff is a community organizer actively supporting Mrs. Biggs Levy, a candidate for the 3rd Ward. Mrs. Biggs Levy is amongst several individuals involved in the recall effort aimed at removing defendant Lewis from her position on the Flint City Council. This context underscores the plaintiff's role in advocating for accountability and transparency within the council. So, given the history, it is reasonable to infer, meaning we can reach this conclusion as a consensus, and it's something that the average person probably would be able to reach a conclusion on based on what we've read so far. And the subsequent events described herein suggest that defendant Lewis harbored personal animosity towards the plaintiff. This animus likely stems from the plaintiff's support for Mrs. Biggs Levy and his involvement in the recall efforts to remove defendant Lewis from her position on the Flint City Council. I mean, if she's effing up and mishandling funds as usual, what corrupt politicians do, get over it. You cannot expect people to want to continue to support you when you're not giving financials. I mean, even by federal law, they're required to do that. So these corrupt politicians don't do it because they don't want people to see what they're actually doing financially. That's inappropriate. It's like a telltale sign. They keep telling on themselves. It's crazy. After the situation had calmed, hold on, I don't want to skip anything. Notably, this warning was directed at the audience as a whole rather than being aimed specifically at the plaintiff. So let's go up. The ensuing uproar from members of the audience who contended that in the absence of a quorum, it is unlawful for the meeting to be called to order and for speakers to be denied their opportunity to address the council prompted Defendant Lewis to issue a generalized procedural warning. And then, of course, notably, this warning was directed at the audience as a whole rather than specifically at the plaintiff. After the situation had calmed, the second speaker approached the podium and inquired whether he was the final scheduled speaker. Receiving no response from the council, he then announced that he would donate his remaining speaking time to another potential speaker. This declaration immediately provoked Defendant Lewis, who contended that the speaker had effectively surrendered his allotted time and consequently neither his nor any additional public comments would be permitted. What the hell? Who does this? Y'all can't hear me again? Y'all can't hear me again? Oh my God. I'm muted again. Is this real? I'm fine. You can hear me? Okay, cool. Sure, can you hear me? I hear you. Okay, cool. All right. I was like, oh no. If something goes wrong again, I'm just gonna stop the live, delete it, and do another one tomorrow. I'm just oh Lord have mercy. I don't know what's going on with StreamYard. Okay, cool. I'm watching the comments, so just let me know if anything happens. All right. So one of the speakers gave they basically, donated their remaining time to speak. The defendant Lewis contended that the speaker had effectively surrendered their allotted time, and consequently, neither his nor any additional public comments would be permitted. Defendant Lewis then ordered the speaker to return to his seat. How did we get here? I mean, what? Why was Defendant Lewis is a she or he? Why would they be upset about somebody surrendering their remaining time? What kind of nonsense is that? At this juncture, a council member declared her intent to leave the meeting, asserting that the session was being conducted in violation of established guidelines and without the requisite quorum. In response, Defendant Lewis characterized her declaration as an improper point of order. How? This is not an official meeting. There's no quorum. It's like meeting somebody at a coffee house. I was watching their meeting from yesterday, and Councilwoman Lewis kicked the citizen off the mic before her time was up because the woman addressed her and said, "Shut the F up." Oh my God. Oh man. Said it was against the rule, but let another lady say about 5 cuss words during her comment right after that and didn't kick the woman off the mic. Yeah, that sounds about right. Because narcissists are hypocritical. This is crazy. Oh man, let me reiterate. This complaint is going to be amended. All right. I hope y'all caught that part in the complaint. This is going to be amended either way, and it's going to get real interesting if they add additional information to this, because this is something else. This is something else. At this point, a male council member retrieved his briefcase and exited the meeting without offering any comment. His departure, along with the earlier exit of a council member, elicited applause from the audience, who recognized that the absence of a quorum rendered the meeting invalid for conducting official city business. Pursuant to established rules, these departures should have resulted in the immediate adjournment of the meeting. Yeah, it should have. Without a quorum, it's kind of like meeting at a park to have a discussion, and then this defendant Lewis getting mad because somebody chose to just walk away. Like, what are we doing? You get mad at someone because they chose to walk away, so now you're gonna cuss everybody out that's still standing there. That's the same thing that happened here. You don't have a quorum. People decided to leave. Now you throwing a tantrum. What the heck? Did someone say if she was a man or woman? Is defendant Lewis a female or a male? Somebody let me know. It just sounds like a female on her period or something. Defendant Lewis was having her time of the month and she just went in the mood. Now she taking it out on everybody. Oh my God. Oh God. All right. Rather than adjourning the meeting following the departure of multiple council members, the remaining few members chose to continue. During this time, a female citizen of Flint approached the podium and delivered a passionate public outcry for 3 minutes, alleging corruption among members of the board. Her remarks underscored the community's growing frustration with the council's actions and governance. Ooh, child. Ooh, child. Okay, Dave Solo, good night. I'm sorry about that. It's pretty late. So catch the replay. Catch the replay. It's gonna be something else. This video will be up for 2 days. Tomorrow and Saturday. Saturday night is going up to the members. Members only. All right, let's keep it going. At this time, the clerk notified defendant Lewis that there were no further speakers to be heard. During this entire time, the plaintiff remained seated and quiet. At this point, defendant Lewis called for responses and comments from the members of the city council. As the council member representing the second ward delivered her remarks, another male council member abruptly left the council table. His departure further reduced the number of present council members to levels well below the quorum required to conduct city business. So if they couldn't have a quorum, of course, council members are sitting there like, look, bye. we going home. What are you doing? You can't force them to stay. What is this person gonna do? Fire them? She can't. What are these weird ass corrupt politicians gonna realize? Everybody is not at your command and control. This is not a cult. You can't fire them. All you can do is be mad and pout and throw a tantrum. That's all she could do. Good night, baby Solo. I know you had a long day, so me too. Oh my good Lord. Let's see. At this juncture, plaintiff approached the podium and inquired of defendant Lewis and the other remaining council members whether the council had achieved the quorum, despite the conspicuous absence of the required number of council members. Plaintiff's inquiry underscored the clear and ongoing deviation from legally mandated procedures, further evidencing the procedural irregularities and the defendant's disregard for established statutory requirements. Upon informed belief, City Council asserted that a quorum had been achieved, even though the required number of members were not visibly present in the room or seated at the table. What is this? The meeting was recorded. Why lie against video evidence? I'm going to say it now. Defendant Lewis is a dumbass. Why? That was a dumb lie to say. Why lie against video evidence? It's in a video that there was no quorum. It was recorded. Good Lord. What is she doing? Taking notes from Super Stupid? Because it seems like a mirror image. All right, plaintiff returned to a seat. Importantly, at no point was any warning regarding decorum issued to plaintiff by any council member. I mean, even if there were, what was he doing that was outside of what normal decorum would be? Oh my good Lord. So yeah, she trying to be a super stupid 2.0 on steroids. Shortly thereafter, Lewis addressed the audience, instructing them to cease their conversation, because of reasons. She further directed that any further remarks or discussion should be conducted in the hallway, thereby preventing any interference with the comments being made by the remaining council members. At the council person's comments ended, after it ended, Lewis placed the council meeting at ease until we can reestablish quorum. Okay. She's doing too much. Shortly thereafter, Lewis observed that a single council member remained in the council chamber. So just one plus her. Relying solely on his presence at the far end of the room, she asserted that his presence allowed them to meet quorum, thereby claiming justification to continue the meeting. But you got to have a certain number of people there present, and they weren't. This assertion disregards the statutory requirement that a quorum consists of a majority of the elected or appointed and sworn members of council. So, how many people on the council again? Somebody give me a rough number of how many people on council. Hey, Mike, how you doing? Because if it's like 5 or 6, 2 people is not even the majority. The majority will still be 2/3. At the very least, you well over 51% as a majority here. 2 people is not it. Defendant Lewis proceeded to commit. Let me see. Hold on. 6. Okay. Yeah. Two two people is only a third of that. That's not majority. So yet again, another goon sitting in this elected position that can't do math or recognize numbers or count. Got it. Lew- Lewis proceeded to commend certain council members on their work while extolling the environmental benefits of urban trees because trees. Significantly during these comments, she never formally brought the meeting back into order, leaving it technically in at ease status. They never had a quorum either. It was only after completing her commendations and when it was time to transition to addressing city business that defendant Lewis stated the meeting could proceed, relying solely on the councilman's return to his seat despite the lack of a proper quorum for official proceedings. She would have needed 4 people there. If it's 6 total, 4 of them need to be there total to have the majority. Yeah. Oh Lord. So the absence of a proper quorum directly obstructed the city council's scheduled acknowledgement of local citizens. Would save another person's life. This procedural failure further exemplifies the arbitrary and unlawful manner in which the meeting was conducted, undermining the opportunity to honor community members, and disrupting the orderly administration of city business. Councilwoman Judy Priestley left the council table and passed by the plaintiff. When the plaintiff inquired whether the meeting was in recess, she clarified that, according to council procedure, the meeting remained at ease until a quorum was achieved. Plaintiff, perplexed by the use of the term at ease, which is not defined within the established meeting rules, publicly requested clarification on this procedural meaning. So in the rules, they don't even have those terms at ease, is what I'm understanding in this. So why use that terminology that's not a part of any rule? You know what? Defendant Lewis is an idiot. You're an idiot. You're using words that are not even a part of the meeting rules. God. This request underscores the ambiguous and arbitrariness inherent in how meeting procedures were applied. Okay, counselor, you trying to use big words. We get it. It's confusing and complex. Yeah, I'm so glad this is being amended. Y'all, I'm tongue tied because ambiguity is what it is. And yet it just says it's complex and confusing and hypocritical. Contributing to the broader context of procedural irregularities that form the basis of this civil rights complaint. All right, cool. Plaintiff, understanding that the meeting was in an at ease status, thereby not officially in session, declared Beverly Biggs for third ward. This act, executed during a period when former procedural safeguards were evidently lacking, barely registered with the audience and elicited no rebuke or warning from any city council member present. Plaintiff's action represented an exercise of his constitutional right to free speech, further highlighting the arbitrary and capricious enforcement of meeting procedures that is central to the claims asserted in this complaint. He approached the podium, requested an additional 3 minutes to speak, asserting counsel was in an at ease state. At that moment, the defendant, police chief Terrence Green, attired in full uniform and visibly armed, advanced toward the plaintiff, accompanied by defendant Villarreal, who was in plain clothes with a sidearm prominently displayed. Together, they demanded the plaintiff immediately get off the mic or leave the council chamber. Why? There's no quorum. Why? This action conducted in a manner that intimidated plaintiff and curtailed his right to speak further evidences the arbitrary and oppressive conduct underlying the proceedings at the meeting. Good grief. What? So the police chief and a detective went to him and said basically he needs to leave when there was no quorum present, and it's basically no different than assembling anywhere else, to which we have the right to do. You have the right to assemble, right to free speech, right to the press, and they're trying to get him to leave for saying what he said. This is insane. Now y'all see why I like reading court documents. This is insanity. If you don't really know what's going on right now with Flint, especially involving Jedidiah, all you got to do is read this lawsuit and you'll get everything you need in once. I promise you, I don't even have to watch all the meetings and the videos or any of that to get a good understanding of what the hell is happening, because it's right here in 31 pages. And this is, man, Flint is the worst. Councilpersons Liddell Lewis and Candace Mushat instructed, directed, or otherwise had the police defendants take the following actions against plaintiff. In the alternative, despite the duty to maintain order at council meetings, including the duty to provide members of the public with safe and free access to city council and to protect the public's rights under U.S. and Michigan constitutions and the Michigan Open Meetings Act, councilpersons Liddell Lewis and Candace Mushat took no action to prevent the following illegal actions against the plaintiff, about which they were aware. I mean, they were there, so they witnessed it, and they did nothing. Oh my God. Councilpersons Liddell Lewis and Candace Mushat took no action to prevent the following illegal actions against the plaintiff. He witnessed it basically with his own eyes. Plaintiff stepped away from the microphone and, seeking clarity, asked defendant Green to explain the procedural meaning of at ease, words that are not listed in the rules. Instead of providing an explanation, defendant Green ordered plaintiff to step away from the mic, and plaintiff then complied by stepping away from the microphone. Despite plaintiff's compliance, defendant Green's microphone direction, and behaving in a quiet, peaceful, and respectful manner, defendant Green ordered plaintiff to get out of the council chamber without offering any lawful justification or cause for his removal, especially given that plaintiff had this unwarranted directive, further evidences the arbitrary and unlawful nature of the proceedings, violating plaintiff's constitutional rights. Yeah, I'm going to just kind of skim over it. We're on page 12. Villarreal remarked on the plaintiff's possession of a bullhorn, which, what the hell? Did he use it inside the chambers? Was the bullhorn used inside of the chambers? Even though no rule prohibits the use of a bullhorn and no violation of the quorum occurred, given that the meeting was in an at-ease state. I mean, once again, even if it were a quorum, what has happened that has actually been considered some sort of disturbing of the peace or disruptive of a, official public meeting? What happened? They got to be able to explain this, which they can't. And the good things with civil procedures, like, any civil proceeding lawsuit filed is based on meeting the burden of a preponderance of the evidence, which means that you just need to be 51% convincing. Is it more likely than not that the defendant committed these, allegations in the complaint? Did they do it? If you got a jury as well, which even in civil procedure, you can get a jury trial. Most people in the jury are going to want to see evidence, to show, okay, were the actions justified and legal? Where are the rules on this stuff? You don't have a rule about a bullhorn. Let me see. Hey, Candia, they also tried to arrest him for trespassing. Are you kidding? Or they threatened to arrest him. Okay. I mean, still, I'm like, why are they wanting him to leave? Okay, my question is, did he use the bullhorn in the chambers? Don't sound like he did. But if there are no rules to even have it inside the chambers, then what are they talking about? These cops are acting like they just don't know how to read, and they certainly don't know laws. This is crazy. Given that the meeting was in an East state, comment further underscores the arbitrary and capricious nature. So you see this repeated out throughout the complaint because I think I've read it like 5 times, where they just trying to lay the foundation to show this behavior is not uncommon. Defendant Green unwilling to permit plaintiff to remain outside the council chamber, ordered plaintiff to leave the building entirely because of reasons. What basis are they doing this under? A bullhorn that's not listed in any policy or rules or anything? Seriously? That's if he didn't use it either, what difference does it make? It could have been hidden underneath his clothes. They wouldn't have even known it was there or on his person if they didn't see it. And then they don't have any rules about it. So what the hell? They're being obviously retaliatory. It's so ridiculous. Defendant Green failed to articulate any law that plaintiff had ostensibly violated or any basis under which plaintiff could be denied his legally protected right to attend a public meeting. This action not only lacked a lawful foundation, but also further underscores the improper and arbitrary suppression of plaintiff's constitutional rights. The police chief, Terrence Green, forcibly removed plaintiff from the public building, thereby denying him his constitutionally protected right to participate in a public forum. Do they not realize that these meetings are available to the public, not just the residents of Flint, Michigan? They're open to the public. Anyone can go on it. You have the news media coming in to cover public meetings now, because we've all seen this with Super Stupid in Dalton and Thornton Township. If that be the case, that means they will be putting out anyone. You have to prove you live there just to attend a public meeting. That's not how it works. You putting someone out of the entire building that does have the right to be there because it's open to the public. That's it. It's open to the public. Good grief. Moreover, defendants Green and Villarreal intentionally used their physical presence to invade plaintiff's personal space and corral him toward the elevator. Are you serious? So what did they do? Push him? These actions constitute an excessive and unlawful use of force that intruded upon plaintiff's rights to free speech, assembly, and due process, and further exemplify targeted suppression of civil rights. Green issued multiple baseless threats of arrest and abuse of power made without any lawful justification. No, you can't just threaten to arrest someone because you want them to leave the building and you can't articulate why. It's almost like they're trying to trespass him, but they didn't actually say you're trespass. Unless I need to keep reading. Maybe they did. I just haven't gotten that far. This is insanity. They're literally handing Jedidiah a lawsuit right now. They're handing it to him on a silver platter. Defendants Green and Villarreal engaged in unwanted and unnecessary physical contact, pushing him into the elevator despite his compliance with defendant Green's unlawful order. These actions constitute an egregious misuse of authority and clearly raise serious concerns about misconduct and the exercise of excessive force under constitutional and statutory protection. His First Amendment rights to freedom of speech and assembly, as well as his Fourth and 14th Amendment rights against unreasonable force and arbitrary governmental action, were flagrantly violated. Goodness gracious. Green reiterated that if plaintiff did not vacate the premises, he would face arrest. Green provided no explanation for why plaintiff should be removed, nor did he identify any law that plaintiff had violated to warrant such an arrest and detention. Well, they've already proven that they're not very smart by arresting him on disturbing the peace a day or two later after the incident and towing his car unlawfully. They didn't have probable cause to tow the car other than them just wanting to do it. This is insanity. Okay, let's see. This failure to disclose a legal basis for his actions further demonstrates the arbitrary and coercive nature of defendant Green's conduct. And if he does this to Jedidiah and was recorded, what do you think he's doing when the camera's not on him? Keep that in mind. What are these two goons doing, and how aggressive and absurdly egregious is their behavior when no one is recording them? This is how they choose to act on camera. This is something else. Such an unfounded threat of arrest not only lacks legal justification, but also exacerbates the violation of plaintiff's constitutional rights. Plaintiff's forced and unjust removal from council chamber, defendant Joanne Gurley, in her capacity as city attorney, failed to fulfill her duty to provide sound legal counsel. She wasn't even telling them what you all doing is legally wrong. And yet, I can guarantee you, a judge would chew that city attorney out. Because at the end of the day, you are there to be neutral and impartial. This attorney went to law school. And it sounds like at this juncture, if they're willing to be this derelict in duty and not actually advise their client, the city, of the laws regarding the meeting rules, the bullhorn issue, the excessive force, all that this attorney witnessed that can be subpoenaed to come in and testify. I mean, they're the defendant, but you're an attorney and you're witnessing this and you don't actually speak on what's happening that's unlawful. They need to be disbarred. This can't be the first time that the city attorney has allowed this dumb shit to go on. Whoever Joanne Gurley is, they need to have their bar license challenged. They need to be reported to the Illinois State Bar. So this resulted in the violation of plaintiff's civil rights. Gurley stood by and allowed the unjust expulsion to proceed without just cause, thereby compounding the harm done to the plaintiff. While in the elevator, defendant Villarreal indicated that plaintiff was being removed due to the meeting's designated order, to which there was no quorum. However, the meeting was in an at-ease status, meaning it was not actively engaged in the formal conduct of city business, and no decorum warning had been issued to plaintiff as required by established procedures. They didn't even tell him why they removed him. So, let's see. While on the elevator, Green engaged in an unwanted and unnecessary physical contact. How did that go? What did they do? Push him? What is going on? This is crazy. Hey, Michael, you say, I saw 2 news agencies across the U.S. tried to shut down people with GoPros. Wow. Cops are at the behest of the mayor. Seems like. And stood guard at the door in case he entered the building before the meeting was adjourned. Are you serious? They did all of this for what? A bullhorn? Oh, they just don't like him? I mean, you can't retaliate like this. This is so obvious what they're doing. They're not even trying to hide it. Criminals are stupid. In case I haven't said this before, y'all, criminals are dumb. Oh my God. Green warned that if the plaintiff did not leave the building, he will be arrested again for disorderly conduct, because they can't even explain what was disorderly about his conduct in the first place. Plaintiff continued walking toward the exit of the building until he reached the area outside the main entryway. Plaintiff requested defendant Villarreal provide his name and badge number. Defendant Villarreal failed to comply with this basic request for identification because, like I said yesterday, who knows if they're real cops? Who knows? No one has to give them that benefit of the doubt, because Lord knows, I know I've seen enough impersonators to be able to say that this should be something they should want to do for transparency. But What's good for thee is not for me, I guess. A local citizen later identified him as Villarreal. Upon a further inquiry by plaintiff, specifically for his badge number, defendant Villarreal stated that he did not possess one. What do you mean you don't have a badge number? Why are you there? So, see, y'all see this? This is why I said that. I just said that. You don't provide it, then I have the right to assume that you're impersonating. Now you don't have a badge number? No, you putting your hands on somebody unlawfully. Be bold enough to stand on that and provide your name and badge number. That's some cowardice shit. It's very cowardly. This failure to furnish standard identification not only casts doubt on defendant Villarreal's authority, which anyone would assume automatically, but also underscores the arbitrary and irregular conduct exhibited during the proceedings. Okay. Upon informed belief, Green Station defendant Officer Guy at the front door as a sentry specifically to prevent plaintiff from re-entering the building. This action further underscores the deliberate measures taken to keep plaintiffs excluded from participating in the public forum to which there was no quorum. Officer H. Guy, whose first name is currently unknown to plaintiff, informed the plaintiff that defendant Police Chief Terrence Green had instructed him to arrest the plaintiff for trespassing if the plaintiff re-entered the building. Who trespassed him? Who trespassed him? Because I don't recall reading that. Was he formally criminally trespassed? Because you need to be criminally trespassed to be arrested if you come back onto the property. That's a criminal trespass. Not a trespass. That's criminal trespass. This is crazy. This directive was issued and enforced despite the absence of lawful justification. Despite the absence of lawful justification to exclude the plaintiff from attending a public meeting or accessing a public building. So they have all the counts. And I'm not going to read each one because it's basically going to reiterate what's realleged already in the background facts. So I'm just going to read the counts out. Like I said, you guys can feel free when you can watch the replay and just, kind of pause to actually read the filing. It's going to be amended. So I'm sure a lot of this is, oh man, count one. A lot of this is going to be detailed even the more with their names and probably, hopefully including the arrest situation. Infringement on freedoms of speech and access, First and 14th Amendment. And then it kind of outlined exactly how the violations occurred. What I'm not seeing is, okay, there you go. I was about to say that. What I'm not seeing is case law cited, but here it is. This is case law. Yay. So if you want to understand how this particular statute, 42 USC 1983, is interpreted, the best way to do it is through case law and precedents that's been set. So you can see how other cases, interpreted the law and how the courts ruled on situations similar to this based on that application and interpretation of that specific law. Hopefully that makes sense. But the case law is imperative to have. I mean, a federal lawsuit like this needs to have case law cited because that's what kind of, gives legitimization to the complaint, showing the unlawful nature of it and what makes this a violation of constitutional rights is constitutional law, which is federal law. You have to have case law cited. So you guys can see there if you want to take time to, like I said, go through this. It'll be up on the channel until Saturday, and then Saturday evening is gonna go to the members only channel. Let's scroll down to the next one. No, let me slow down. Y'all can, if you want to pause and read. There you go. And just for the sake of brevity, because like I said, this is 31 pages, and I don't, I've been told before, start reading everything. We can read it. Then why are you in this video? But it is a lot to read. So, Y'all see where we're at paragraph 90 here. This is still under the first count, by the way. The background facts is like kind of giving the foundation to it, and each count that's listed is specific to each law or violation of that law, plus the case law included. So it's like a breakdown. Ooh, man. Let's see. Count 2. There we go. Conspiracy to interfere with civil rights. And then, of course, they give a breakdown. You guys see case law cited here. And case law, okay, listen carefully. Case law is only established once the actual case, the matter has been resolved and adjudicated in the court of law. You cannot cite a case that is still actively pending in the court. That is not case law. There is no ruling or decision made from any jury or the judge from any hearing. So open pending cases cannot be case law. You can't cite a case that's still being heard and adjudicated through the court, because how do you know it's going to go one way or the other? You got to let it get resolved, get the ruling. The judge typically will, especially in federal cases, like whether it be criminal or civil, the judge is going to give a full summary as to why they gave the ruling and support it. So let's keep scrolling. Okay, count 3, negligence per se, violations of the Michigan Open Meetings Act. And then they give the breakdown here. They cite the law itself. And you guys, the Open Meetings Act is federal law. So each state adopts some of these federal laws, and they basically just kind of reiterate what the federal law is stating. And this is the Michigan Open Meetings Act. Typically, they're not really altered or changed too much. They may have a couple nuances here and there, but it should not deviate from the federal law itself. Let's get to it. And I apologize. This is more lengthier than I wanted it to be, only because I kept having audio issues. Ugh, man. And you guys can see here, they're citing an exhibit, which I do have. So I'll show that in a minute. This is going to be, man, this lawsuit is something else. Count 4, assault. Yeah. Battery should be like one of the counts as well. Why put your hands on someone? And they didn't even did they ever take time to actually criminally trespass him? Because if they didn't do that, then they're just a joke. And I can't take these people seriously. If they didn't even give a criminal trespass, no, I can't take it seriously. Count 5, intentional infliction of emotional distress. And you guys can see that here. And here's the prayer for relief. Wherefore, for the foregoing reasons and pursuant to the counts above, plaintiff Jedidiah Brown demands judgment against defendants as listed in the alternative for general compensatory and punitive damages, reasonable attorney's fees and costs of suit with interest pursuant to 42 USC 1988, and any further relief which the court may deem equitable and just. There is a jury demand, so there's going to be a jury trial. If it gets to that point, I don't know. I haven't really, read a whole lot of cases regarding federal lawsuits pending against, any person in Michigan or Flint. So I don't know if they're going to be willing to settle. More than likely, they may try, because stuff like this, let me tell you something. The worst part about, what these defendants don't like to do when it comes to these type of cases is have to go have a jury trial. And then all of that discovery, all the evidence and the exhibits, all the videos, the witness statements, testimonies and stuff, they never want that to come to light, right? So most times they do try to just resolve it just to keep from having this stuff come to the forefront. So I will be shocked if they really try to push this to a full trial hearing with a jury, because the jury is going to see all this evidence. And then, of course, the certification, um, which is kind of like the affirmation of this actual complaint, and completed by Lento Law Group Lawrence A. Katz. This is attorney. April 29th, 2025. All right. So that's the full lawsuit right now. That's going to be amended. And here's the exhibit A. This is State of Michigan. What is this? Oh, the Opens Meeting Act. Opinion number 6499. Okay. So you guys can see here, this exhibit is basically a copy of that. And then let's see. You request my opinion on the question, which may be stated as follows. Yeah. So this is kind of just a, you know, opinion on the actual Open Meetings Act itself. You guys can see here. This is 2 pages. And then they give, they cite case law here too. And they couldn't even, uphold their own their own state law. The councilman or councilwoman. This is something else. This is something else. All right. So that's the full lawsuit and complaint. I do expect this to, like it's cited in the actual complaint. This is going to get amended. But if I had to give my 2 cents on the complaint itself, I would tell um, the attorney to, remove statements that are repetitive, because judges don't like to read all that. I'm gonna tell y'all that right now. Judges do not like to do all that reading. I don't know why. They went to law school. That's all they did, and they don't like to do all that reading. But that's it, folks. That's all I got. Tomorrow I will go live, and I'm gonna do a couple videos that are just gonna be live, like premiered. But you guys can see here, this is something else. Flint need to figure some things out, because otherwise they got a whole lot more lawsuits coming their way. But you guys leave comments below. Let me know what you think about this. This is going to be interesting to see unfold. Once the amended complaint is filed with the court, we will go over that. Hit the like button before you guys check out. I know it is late. My apologies for that, and for the issues with the sound and all of that. And you guys make sure you subscribe if you're enjoying the content. This video will be available until Saturday evening. Give people a couple days to watch it, and then I'm going to make it available to members only. So consider becoming a member. You want to be able to catch all the good stuff. You guys be sure to share the video. Take care of yourselves. Have a good night. I'm going to bed. And until the next one, Lady Luck out. Deuces.